Probate without a will, also known as intestate probate, occurs when a person dies without leaving a valid will to direct how their assets should be distributed. In this case, the court oversees the process and the state intestacy laws determine how the estate is divided amongst the deceased heirs. Here's what happens typically in a probate without will, for example. So there has to be an administrator appointed. Since no executor is named in a will, the court appoints an administrator to manage the estate. This person has similar responsibilities to an executor, but is appointed by the court, typically a close relative. Next, the administrator works with the court to identify legal heirs based on the state's intestacy laws. These laws prioritize close family members such as surviving spouse, children, or parents in determining who will inherit the estate. The next step would then be to settle the debts and taxes. The administrator is responsible for paying any debts, taxes, or expenses out of the estate's assets before distributing what remains to the heirs. And in the process of distributing assets after the debts and taxes are paid, the remaining assets are distributed to the heirs according to the state's laws, which typically follow a specific hierarchy, so spouse, children, and so on. A probate without a will can sometimes be more complex and time-consuming because the court must take an active role in the decision-making. It also removes the ability for the deceased to choose how their assets are distributed, defaulting instead to the legal framework.